Understanding whether your LTD claim falls under ERISA or state law is crucial if you want to receive the monthly benefits you need. Long term disability claims can be complex, and the differences between these two types of claims can significantly impact your rights and options. Hi, I'm Leah Small, a managing attorney here at Chisholm and Kilpatrick, a nationally leading public interest law firm based in Providence, Rhode Island. Today, I'm joined by CCK founding partner Robert Chisholm. Today, we'll be discussing the key distinctions between ERISA governed and state law governed LTD claims and how these differences may affect your claim. Before we begin, be sure to like this video and subscribe to our channel for more long-term disability content.
Thanks, Leah. So, as you mentioned in the opening, there are generally two categories of LTD claims, ERISA governed and state law governed. Can you start by explaining what ERISA is and why it's important in the context of LTD claims?
Absolutely. So ERISA stands for the Employee Retirement Income Security Act of 1974. This is a federal law that governs most employer-sponsored benefit plans, including long-term disability. This law sets the standards for how these plans are administered and provides protections to employees. It also creates a distinct legal framework for claims and appeals. Now, this can be different from state law.
With that in mind, how does an individual know if their LTD claim is governed by ERISA or under state law?
Most employer-sponsored LTD plans are going to fall under ERISA. However, there are some exceptions, such as church employers and government employers. Alternatively, individually purchased policies typically fall under state law, although there are sometimes exceptions if you purchase an individual policy through your employer, so it's important to be aware of that. People should check with their employer to figure out how they obtained their coverage and read their policy carefully, as it may provide some information whether it's ERISA governed or state law governed.
Okay, so what are some of the key differences between ERISA and state law governed long-term disability claims?
So there can be a few differences. Number one, ERISA generally requires claimants to exhaust all internal administrative appeals before they can file a lawsuit to obtain their long-term disability benefits. Alternatively, state law governed claims may allow a claimant to file a lawsuit sooner. Again, it's going to depend on their state law and the terms of your private policy, though. Additionally, in a lawsuit, evidence and discovery varies greatly between ERISA-governed claims and state law-governed claims. Generally, for ERISA-governed claims, your case is going to be limited to the administrative record, and claimants usually cannot submit new evidence in court. Alternatively, for state law-governed claims, you have the more traditional opportunities for discovery and presenting new evidence in court. Finally, another important distinction is the standard of review. Under ERISA-governed claims, you may be facing the arbitrary and capricious standard of review, which gives deference to the insurance company's decision. In state law-governed claims, it's more likely to be a less deferential standard, such as de novo or just a straight preponderance of the evidence standard. Additionally, when you're in court on an ERISA-governed LTD claim, your recovery is typically going to be limited to the past due benefits and potentially attorney's fees and interest. You generally cannot pursue punitive damages or damages for emotional distress or other things like that. Alternatively, state law-governed claims, again, depending on the laws of your state, may allow additional remedies such as punitive damages, emotional distress damages, and other things like that. Finally, it's also important to be aware that ERISA-governed claims that go to court aren't going to be in front of a jury or have witnesses or things like that. It's typically going to be a judge-decided issue on the papers. Conversely, again, state law-governed claims are going to be that traditional court case that you think of with a jury and witnesses and those types of things.
So when I think of ERISA claims, Leah, what comes to mind for me, first and foremost, is that while the case is before the insurance company, sort of administrative part of the claim, it's really important to create a solid record.
Correct.
Because once you go to court in ERISA, the standard of review isn't very favorable to the person applying for benefits as a practical matter.
Potentially, correct.
If you need assistance with your claim or appeal, CCK may be able to help. Since 1999, we've been helping LTD claimants get the benefits they need. You can contact us either by filling out an online form on our website or by calling us directly for a free case evaluation with a member of our team. Remember to like this video and subscribe to our channel. And don't forget to leave a comment below if you have any questions. Take care.